Next, we have a panel of two, if you will, that will talk about the Supreme Court decisions on homosexual marriage and what it means to the church and the conservative movement. We have to understand, and I think Ted really got into it, that elections have consequences. And we need to make sure we have, when we go to vote, that our vote counts for something and we stand for our values. Because whoever we put in office, especially the President of the United States, gets to pick who's going to be on the Supreme Court. And, a lot of these decisions end up coming to the Supreme Court. And sometimes they don't, get, well, let me be quiet and let the lawyers talk about this. I'm going to call them up and let them actually introduce themselves, because I have Marc Little's biography, but I don't have Peter Breen. So I figure if I'm going to do it right, I'll just let them talk about themselves for a few minutes and about what they do, who they are, as they get into the topics. Here's Marc Little and Peter Breen.
The microphones.
Oh, we're mic. Yeah. Okay.
You're supposed to turn it on.
Okay. Excellent.
All right. Are you on?
Can you hear us?
All right.
Excellent, excellent. I am Marc Little. I'm an attorney from Los Angeles. I'm a pastor and the author of a book called The Prodigal Republican, Faith and Politics. And so that fits very squarely with why we're here today in the context of defending the family. And so before I begin to speak, I'm going to speak about Prop 8 and what's happened in California. Before I do that, I'll turn it over to my colleague to introduce himself.
Thank you, Mark. My name is Peter Breen. I'm the Vice President and Senior Counsel from the Thomas More Society, which is a national public interest law firm headquartered here in Chicago. And I've been litigating on this issue and other issues of life, family, and religious liberty for several years now. I also happen to be an elected official in the village of Lombard, which is in the western suburbs, and I am a candidate for state representative in the state of Illinois.
Excellent, excellent. Excuse me. Before I get started, I want to let you know that I've left an outline of the procedural summary for Prop 8 over on the table, because we really don't have time to go into all that has happened in that case. But if you're interested in the detail of it, I've left that for you, just a few copies there. Before I get started, though, I do want to thank Dr. Eric Wallace for this vision. I'm so pleased to be here, to have been invited, and so congratulations to you on this event. Secondly, I was so charged up this morning after listening to Wayne Perryman and my friend Star Parker. If you missed that, get the DVD, because it was certainly invigorating and inspiring. And so I was glad to have been able to be a part of their presentations. And then finally, what was a great surprise was the presentation by the Slaters. So not only do I thank them for that presentation, and what I will take is that DVD back to California to my congregation of some 13,000. And through our political action ministry, I want to be sure that we understand not only what's happening in California, but what our government is doing globally, which was really quite news for me today. And so I thank you for that. And then I get to thank the African Coalition for the work that they're doing to protect their own rights in their countries to do and believe as they wish. And so that was really, really inspiring. What I know about where we are in the fight for marriage is that it is a struggle between a biblical worldview and a contemporary worldview. The Bible is very clear in Genesis 2 and 22 and Proverbs 18 and 22 that marriage is between one man and one woman. The Bible says that he who finds a wife finds a good thing. And so let's be clear what this is. This is a spiritual battle, for we wrestle not against flesh and blood, but against principalities, against powers, against rulers in dark places. And so it's very clear in Ephesians 6 and 12 what this is. And so the answer, of course, is prayer. And so that's what I'm able to take with me, even as being a lawyer and understanding the challenges that Mr. Breen and I will share with you. At the end of the day, there is victory because it's not about flesh and blood, but it's about prayer. Amen? Let's be very clear about the agenda that was so well highlighted in the presentation, Cultural Imperialism. The agenda is well funded, it's well organized, and it's very strategic, and the goal is to normalize same-sex marriage across all 50 states. Let's be very clear that the agenda is very focused, and they are succeeding where they are attempting, and they're very deliberate. And it is a war. And so I want to just briefly describe in California what we're dealing with. You may have heard of Common Core instruction. I have a charter school that we started 3 years ago, a charter middle school. And now, because of Common Core instruction, we will be faced with the impacts of that with K through 12 that require us to talk about the contributions of LGBT folks throughout history. And so that's very significant, and it's a very serious thing. We've also been faced with, and thank you, Ted, by the way, for what you said earlier, we're faced with laws now that prevent us from counseling in the state of California those who have sexual identity challenges. We recently have been faced with Assembly Bill 1266, part of the war. I'm leading up to Prop 8, but part of the war is now what we call the transgender bathroom bill. In the state of California, they've now passed a bill where if you identify with being the opposite sex, you can now participate in programs or facilities like bathrooms with which you identify. So if I identify as a woman, I can now use the girls' bathroom in public schools. We got a real problem happening in the state of California. And the saying goes, as California goes, so goes the nation. And there is some truth to that. And so we are fighting best we can. There's a coalition that has formed. They need 500,000 signatures by November 12th to be on the ballot. You have to be a California resident, but you should look that up so that you can follow what's happening in California, because it will impact you where you live.
Just to interrupt, though, folks in Illinois can vote anywhere. I don't know if you all knew that.
I didn't know that.
Yeah, we're very creative with our voting rules here. So.
Oh, that's good to know.
Yeah.
My goodness. And then leading up to why I'm here is the state of marriage in California in general. And the question really has become the ability of government officials to arbitrarily decide to not enforce the law. And the second question is that a federal judge, one man, can overturn the will of 7 million voters, 52% of the electorate, who passed a constitutional amendment that we call Prop 8. And that's really the core of the issue. I'll get into just a little of the minutia, but again, I encourage you to read the procedural summary because, and I'll share with you just a little bit of the rationale of the district court judge that really is what we're left with in California as to what he's thinking and what's to come. And then let's be clear that we've got the IRS, who passed just yesterday, that I'm sure my colleague will talk about, that allows now same-sex marriage couples to file joint tax returns, no matter where they live, as long as their marriage is considered legal. And it's coming, this ideology is coming to a church near you. And so as a pastor, I'm following all that's happening across the country, where we have florists who have decided to stand up for their faith and not support couples who are engaged in same-sex marriages, and they're now being sued. Of course, that's going to put them out of business, right? And we have cases like that that are sprouting up all across the country, and churches will be sued eventually for not performing same-sex marriage ceremonies. And of course the goal is to attack our nonprofit status, and then ultimately to say that we cannot preach against homosexuality. They're clear. They're not hiding what their goals are. And so we need you to continue to follow these fights and to stand with us, because ultimately our civil liberties will be attacked, not only in this area, but it will grow across the board, because ultimately the attack is against Christianity and against our faith. Amen? And so just as a foundational matter, marriage between one man and one woman is certainly been the foundation of all of the states. And in California particularly, Prop 22 in 2000 codified that in the Family Code section. And then in 2004, our current Lieutenant Governor, Gavin Newsom, began to just allow same-sex marriage licenses to be issued. And that's what sparked the debate and the condition of where we are today. And so after he did that, several cases were filed that are called in re marriage cases, where the Supreme Court affirmed the law and said, no, you got to stop this. You got to obey the law, which is marriages between one man and one woman. The group called Protect Marriage then began to say, look, okay, if you're going to challenge the law in the state of California, we're going to amend the Constitution so that it is clear what California says and thinks about marriage. And that's when Prop 8 was passed, again, as I said, by 7 million voters and 52% of the majority. The California Supreme Court then, in the very next day, received filings against the governor of the state then, which was Schwarzenegger, and the then Attorney General, our now Governor, Jerry Brown. And they, as you may recall, refused to defend the law. And that's when the Protect Marriage group came forward and began to defend it on behalf of the citizens of California. And then in May 22nd, 2009, Perry versus Schwarzenegger was filed in the U.S. District Court, because the California Supreme Court said that Protect Marriage had standing, and they affirmed the law. It was then appealed on constitutional grounds under the 14th Amendment, that it was a violation of due process and a violation of the Equal Protection Clause. And ultimately, Vaughn Walker, who is known as an activist judge and as an openly gay judge, made a ruling that struck down Prop 8. And I'm just going to read to you one or two things that he said that gives you the rationale for where this is going. He said he found no evidence that allowing same-sex couples to marry would harm opposite-sex couples. He found there's no material difference between same-sex and opposite-sex relationships. Relationship satisfaction, relationship adjustment, and love do not differ depending on same-sex or opposite sex. He found that the state of California has no interest in differentiating between same-sex and opposite-sex marriage. He says that Prop 8 only finds support in disapproval, and as such is beyond the constitutional reach of the voters. He said that fundamental rights are not subject to a vote. He went on to say that gay and lesbians have been victims of a long history of discrimination. And finally, I'm going to read his ruling. Proposition 8 fails to advance any rational basis in singling out gay men and lesbians for denial of marriage licenses. Indeed, the evidence shows that Prop 8 does nothing more than to enshrine in the California Constitution the notion that opposite-sex couples are superior to same-sex couples. Because California has no interest in discriminating against gay men and lesbians, and because Prop 8 prevents California from fulfilling its constitutional obligation to provide marriages on an equal basis, the court concludes that Prop 8 is unconstitutional. And I've written that for you to digest, because those are harrowing words. Those are frightening words for a judge to make as a legal basis for striking down the will of the people. Protect Marriage filed an appeal before the Ninth Circuit after affirming protecting marriage's standing in California Supreme Court. The Ninth Circuit ruled that the district court's ruling would be affirmed. Protect Marriage then affirmed it to the California Supreme Court that said they had no standing, which was affirmed by the California Supreme Court, that in fact they did have standing. So after they struck down the Ninth Circuit's opinion, what we're now left with is Vaughn Walker's opinion that strikes down Prop 8. But here's the point about the district court's ruling. Only 4 counties were before the court: the county of Alameda and the county of Los Angeles. And only 4 plaintiffs were before the court, which should mean that the ruling should be narrow as it applies to the district court. But what happened after the Supreme Court struck down the Ninth Circuit's ruling, the Attorney General, Kamala Harris, issued an opinion that it now applied toward the entire state, and that Prop 8 could not be enforced by anyone. And so now the standing is that everyone in the state of California can now be married, same-sex marriages can go forward, which is in contravention truly of the very narrow ruling and the narrow injunction that Judge Vaughn Walker made. And so, unfortunately, the Protect Marriage group filed a writ before the California Supreme Court with that argument that this was a very, very narrow ruling that should not be applied statewide. And without a legal basis, the California Supreme Court simply denied the writ. And so now the state of marriage in California is that same-sex marriages are allowed to occur against the will of the people, against the clear ruling of Prop 8, that marriage should be against one man and one woman. And so that's what we are left with today. And so what we need is your prayers, because we've got to be able to combat what's to come, which is an attack against the church, which is an attack against every business that will stand on their own faith, that says we don't want to compromise our faith by not being a part of a same-sex marriage wedding. And so that's what's on the horizon for us, certainly, and I believe that's what's on the horizon for you. Thank you very much.
With the pastor's leave, I'm going to take the podium only because early on in law school, I had a professor who would not let us answer a question unless we stood up. And so even in court where they'll say, oh, well, counsel, you can sit down, I'll still stand up when it's my turn to speak, just because it's an old habit and one that I follow through to today. I think I'm on this microphone anyway. So I've been asked to come forward and talk about the Windsor decision. And so that's the decision by the U.S. Supreme Court to strike down Section 3 of the United States Defense of Marriage Act. That is not an easy topic, because Windsor was a terrible and poorly reasoned decision. As a constitutional attorney, I know of certain standards when you challenge a particular provision of the United States Constitution. So say if you're challenging under the Equal Protection Clause, there are 3 tiers of scrutiny that one could apply, and you make a decision which tier you're going to apply, and then you apply it. Under the Due Process Clause, you would talk about the history and traditions of the country. In Windsor, Justice Kennedy mashed all of the standards together, sprinkled in words about federalism, and then came out with an opinion that really didn't satisfy. It was the sort of thing, as a constitutional lawyer, you'd look at and go, well, what did you just decide? So from my perspective, I would rather talk to you today about the effects than the particular legal reasoning. I will talk a little bit about the dissents, because there was a dissent by Justice Scalia, and there was a dissent by Chief Justice Roberts that were of note in that decision. I also want to recognize the many good friends I see in the audience here, and because I see so many good friends in the audience, and I've talked with many of you about these issues, I know that you are concerned, you are worried, sometimes even tempted to despair over the Windsor decision. And now I don't want to sugarcoat it. It was a terrible decision. But at the end of the day, Windsor left the door open for us to continue the fight for our understanding of the purpose and nature of marriage. So it shouldn't be a lot of comfort, but it should be enough to know, look, the barbarians are at the gate. And if we don't do the work here in the next few years to change the culture so that the nature and purpose of marriage, as the lifelong union of one man and one woman open to children, if we don't educate on that, we will lose. Now, we may not lose the majority of states, but eventually a case will make its way back to the U.S. Supreme Court. And if we don't create the culture of marriage, the U.S. Supreme Court will feel comfortable overturning our law. And as many of you know, in the legal field, lawyers lean to the left on a lot of issues, particularly on the social issues. I don't know what it is about law school that does this to us, or if it's just self-selection on the way in, but that is a fact of life. And so as the lawyer pool goes, so does the judicial pool. Certainly having presidents who are more conservative can help to stem that tide, but they can't stop it altogether. So that's really where we are in terms of that, standing in society. Now, there were two dissents that I'm going to talk about. I hear a lot from folks, and when I talk doing radio interviews about this decision, everyone jumps to Justice Scalia's dissent, where he said that the Windsor decision would be used as a lever to bring same-sex marriage to the states, and that essentially the fight was lost. I respect Justice Scalia. I read him. I see his dissent more in the idea that, hey, we're really on the precipice, but I don't think that his conclusion that we've already lost is one that we should accept. And I believe that Chief Justice Roberts really gives us a way forward. He said, look, in the majority decision itself, it said that it was limited only to those states and those marriages that were lawful. So lawful under those, the 13 or so states that have same-sex marriage. Right now, I am, in my cases, we're litigating several cases on the issue of marriage. We're trying to hold the Supreme Court to its own words. That narrow 5-justice majority said that it was a limited decision. Here in Illinois, we at the Thomas More Society have been appointed special assistant state's attorneys for 5 different downstate counties. And we're in front of a Cook County circuit judge. And here in Illinois, we had the same sort of situation that they did in California, where the Cook County state's attorney refused to defend the law. The Cook County clerk, her client, agreed with the plaintiffs. The day that they filed the lawsuit, he put out a press statement saying it was wonderful he was being sued and he agreed with the plaintiffs. It's not the typical legal posture. Certainly not. The Attorney General got into the case a few days later. And remember, it takes an Attorney General usually weeks even just to begin to think about a case, much less than another few months to file papers in a case. And this Attorney General got in within days, filing papers, intervening in the case to oppose our state's marriage law. We had learned, the attorneys who litigate these cases on a regular basis had learned we needed to get public officials in quickly, and we had formed relationships here in the state of Illinois that we were able to get those public officials online and get them into court. So we were able to do that, and that is something that you are seeing here in this state as we fight against same-sex marriage. And that's not my topic, but it is something that very specifically here, the unity between the black community and other, the Illinois Family Institute and other institutes and institutions has kept same-sex marriage from sweeping Illinois. And that same effort is also what's helped us with our political leaders to get them into court and to stand up for marriage. Here in this state, we even had leading state legislators filing briefs in support of marriage and making very strong statements in those briefs. So all of that packaged together. Again, the Windsor case, not a good decision, but we do still have an opening and we are still fighting very, very hard. I want to give you a little preview of some of the confusion that my friend Marc, he referred to. The decision by the IRS now to treat every marriage, wherever solemnized, as a marriage under federal law for tax purposes is actually not the first federal government decision on this issue. The Office of Personnel Management issued a decision about what it believed that federal employees, what their marital status should be. The Social Security Administration had issued its decision. The problem is all of their decisions are different. I don't know if you knew that. The IRS has taken a very broad view of it. The other two entities had not taken as broad a view of it, such that you're going to see more confusion. This is not, I don't see it as helpful for us because I think anything that blurs the line between natural marriage and relationships that are not natural marriage is not helpful for us going forward. So I would oppose those particular rulings, and I would urge you to do the same. We're going to have some rough times these next few years as the federal government, under the current administration, does everything it can to recognize these relationships. But again, my message to you is keep the faith. I see a lot of good people here today that are part of that task of keeping the faith and moving us forward. And with that, I think I will sit with the pastor and begin our fireside chat portion of the evening, or afternoon.
And so we're available to any questions if you have any. Ken?
Hold on, we're going to get the microphone for you.
Thank you. Is it an accurate assessment to say that the Windsor case is really the result of Attorney General Holder and President Obama not enforcing, because as I understand it, she brought this case, the woman brought it to the courts and to get her partner's death benefits. And they were ordered to, the IRS was ordered to give her the benefits, but they didn't comply. So it was a non-compliance really by the Obama administration, was it not? And so it shouldn't have even reached the Supreme Court. Is that right?
Well, I will say the fact that the Supreme Court declined jurisdiction in Prop 8, where it probably should have taken jurisdiction, and then accepted jurisdiction over Windsor was a confusing part of this. In Windsor, there was a defense of DOMA. The United States House of Representatives, through their bipartisan legal advisory group, filed sought leave in order to defend the Defense of Marriage Act, and they were allowed to do that. Supreme Court allowed them to do that. In terms of the compliance or non-compliance, that actually, it's kind of interesting. Gavin Newsom was issuing marriage licenses, and that was the wrong thing to do. The right thing to do for an executive branch office is to follow existing law until you're told by a court that it's been overturned. So by disallowing the tax refund, that was the correct result right now. So I wouldn't blame the administration for that. I would blame the administration for not defending a valid and presumed constitutional law in the courts and forcing the U.S. House to come in and try to defend it in a very strange legal posture. I mean, in our system of checks and balances, the executive is supposed to faithfully execute the laws. And in numerous states and in our federal government, we have an executive branch that refuses to faithfully execute the laws. And that's the real problem you see here. I mean, we have a careful system where the executive has its role, the legislature has its role, and the judiciary has its role. Unfortunately, our executive branch is out of whack right now, and this is just one of the many areas where that's occurring.
As a follow-up to that, can I just ask, this new Marc Levin book where he's talking about in order to avoid what you just talked about, how the executive branch is sort of taken over, do you think that's possible here in Illinois or all around the country?
Oh, boy.
Which amendment in Mr. Levin's book are you referring to? Which amendment in his book are you referring to?
The Liberty and Amendment book, the one he just released.
No, I know the book, but,
Oh.
but which,
I was just wondering if you see that as something, the reason why I'm asking this is it seems like we're always reacting rather than acting, and I'm really grateful for Levin and his push to get the states to consider, allowing it so that, the executive branch isn't by fiat, doing what they want. And
one of his positions, of course, is that judges should not have life tenure. And so I think that's what you're referring to. And good luck. I agree with that, but there's going to be a lot to have happen before that changes. But Marc Levin, if you don't have the book, I recommend it highly. He's on to something. It's not radical in my opinion, and I think if we follow some of his lead, we'll be much better off, particularly judicially.
The First Amendment guarantees that the government will not establish any religion. With the current climate, and I would think even encouragement of people to look at the gospel message, preaching, and those things that we predicate our faith upon as possibly hate speech, religious bigotry, etc. Isn't the government, in fact, now seeking to establish a brand of religion that is acceptable to its own principle?
I think that that's rhetorical. It's absolutely correct.
What can we do?
We have the Nixon Amendment that led to the inability for churches to speak politically, and I think that's the first step, is getting rid of the Nixon Amendment so that churches can be more engaged.
And I would say, too, to that, one of the problems we're running into as attorneys in court is a creative legislature can get its way. So as an attorney, I've got all sorts of creative ways to come back after a bad piece of law, and sometimes we need a little judicial activism on our end because these laws have gotten so out of hand. You want a robust First Amendment. I talk to Republican judges, and they are loath to strike down a government action based on, say, the free speech or religious liberty. We want them to strike down those actions. We want a nice broad right to the Bill of Rights. And so, you look at decisions like the one in New Mexico, where the state of New Mexico will compel a private photographer to spend all day, to spend time planning a lesbian wedding photography session, spend all day at the lesbian wedding, spend all her time afterwards lovingly preparing a photo album for the lesbian wedding, and then presenting it to the lesbian couple and considering them as married. That is now required to be compelled under New Mexico law, and the New Mexico District Court, Appellate Court, Supreme Court found no problem with it. And if you haven't read that decision, it just came out very recently. It's called Lane Photography. The concurrence is bone-chilling. Yes, the concurring justice used the term that he said that this compliance is, quote, the price of citizenship. And that compliance is really it really is taking what is a fundamental tenet of the Christian faith and forcing you to act against it. That is the price of American citizenship. I hope that decision, I hope that the U.S. Supreme Court takes that case and overturns it. But that's what we're facing right now.
Thank you. A comment and then a question. To add insult to injury, not only did President Obama and Eric Holder not defend the Defense of Marriage Act, but some of you may be aware that under President Obama, the United States joined the United Nations Human Rights Council again. And that means that the United States has to come before the Human Rights Council and let anybody can complain about how we've abused human rights. And in an unprecedented step, our own government complained against itself and said that we were abusing human rights with our Defense of Marriage Act and our Don't Ask, Don't Tell bill, and that they were going to do something about it. Just outrageous. That was my comment. My question is, you said they're supposed to be defending the law. That was their job. So what discussion has been happening? Is there any remedy to this? What can we do? Where's the pushback? We keep talking about the fact that this is terrible, but what can we do about it?
I'll answer in two ways and then let my colleague answer. First, I want to say As relates to the United States and its global mission, I want to add to something that you did in the cultural imperialism piece. We also have a policy of population control, where we are controlling nations by our purse. And so if you're not aware of the things happening in the United Nations, Project 21 and other things, please make yourself very aware of that. Secondly, to answer your question directly, I think it's very clear that what we must do, both as believers, as the church, as a body, is we have to do what the Bible says. We have to elect godly leaders. And so when you have a president or an attorney general like we have in California, both in Kamala Harris, beautiful black woman, by the way, but notwithstanding, and then Jerry Brown, who simply don't fulfill their obligation under Article 3 of the California Constitution, what we have to do is stand up and say, we recognize that you are not fulfilling your obligatory obligation, and we're going to unelect you. And just as they did in Illinois, I was so very pleased. That's the model. A handful of people can stand up and change a state. If a handful of people can stand up in a state, a handful of people can change the country. We're not standing up. And so that answers your question from my perspective.
And I can only echo that, and that's what I would. Let me tell you that the difference between the Prop 8 case, which could have gone differently had they been able to get courageous county clerks to stand up immediately, and our case here in Illinois, which we learned the lesson, we went right to the county clerks that we could find. Now, there are 102 in Illinois. One of them, of course, was the defendant, David Orr from Cook County. But of the other 101, most of them would consider themselves or publicly say, I am in favor of traditional marriage. Although we did have to scratch and claw to get a couple. We started with 2 out of 101. We got up to 5. And we figured 5 was enough. But at the same time, we did work very hard on that political side. You wouldn't normally think about, hey, who am I electing as my county clerk? And what are their values? What are their beliefs? You might say, well, it's a county clerk. Right. But when we need them, and we may not need them often, but when we need them, we need these elected officials very badly. And so I can only echo what Marc said, which was, hey, you watch these folks from the top of the ticket all the way down to the lowest level. Precinct committeemen all the way up. Get folks that you believe in and who you think are going to improve our life together and who will serve civil society to the positive, to the public good, to the common good.
And I would only add, certainly what we do at my church in Inglewood, California, we have a political action ministry. And a lot of churches are unclear about what they can and cannot do in the political realm. And so I'm very deliberate in informing. You're able to inform, you're not able to support one political candidate over another, but you're able to inform. The unfortunate thing is the conservatives, who are typically Republican, don't necessarily show up in black churches. So they're not hearing the other side. And so we have to be deliberate in getting the message out, the message of information about what is happening. And that is allowed under our tax-exempt status. So I encourage you to have political action ministries that understand their role and make sure they're engaged and operating so that people are informed.
And to be clear, you can register voters.
That's right.
You can encourage people to vote. I know you can say vote, for instance, vote pro-life, vote pro-marriage.
Anything that's faith-based, you can advocate.
Right.
You can advocate faith-based issues.
Sure. And then in a separate homily or a preaching session, you can then talk about the candidates and their stances on matters. Just you try not to mix the two of them together.
Right.
Just to be
And pastors are individual citizens. You can stand up and say who you're supporting. You simply cannot tell your people who to vote for. But you can make it very clear what you're voting for. All right, amen? Any more questions?
Yeah.
Yes,
Okay.
ma'am.
I have given a lot of thought to some of the things you spoke about the executive branch out of control and doing things that are against the will of the people, Obamacare included, and the judges out of control, which are making rulings that are against the will of the people. And I just would like to get some feedback on a possibility, which is Abraham Lincoln said in 1863, government of the people, by the people, for the people shall not perish. How do the people govern? And one thought I have is that when the executive branch is out of control, what about a referendum process where things of major impact are put to a referendum and the referendums are given to the elected officials in Congress? You must vote this way, not you can or think what you want to do, but to direct the elected officials how the people want them to vote on the statewide and referendums, a binding referendum. And then for the judges, I'm also thinking an amicus brief by the people, so that if the people feel really strongly about an issue, then there would be somebody who would write that in the amicus brief, and then 100 million people sign that brief. The judge has to take into account an amicus brief by the people.
I'll respond and then allow my colleague, but first I want to be respectful of time. How are we doing in this session, Eric? How are we doing on time?
We're actually going a little bit over.
Oh, okay.
Okay. And so here's the problem. When you look at the issue and understand that there is an agenda that undergirds all that we're talking about, when you talk about amicus brief and you talk about how to influence the legislative process, you have to understand what you're dealing with. First of all, it's spiritual warfare. We can't overlook that fact, because there are people with agendas, no matter what the petitions say, they have an agenda, and they're going to carry that out because they think they know best. That's why we have judicial activism the way we do today. And so we have to understand that. And that presents the largest challenge, because it's an agenda that doesn't care about what we think. And then secondly, I simply go back to what we said earlier. You have to be engaged in the civic process. And the folks who are ignoring the will of the people. California is unprecedented that you have a constitutional amendment that was completely ignored and overturned by one man.
Yeah. One trial judge. I mean,
one trial judge.
Yeah. They don't do that.
It's unbelievable. And so when you talk about the legislators, you talk about the judiciary, you have to understand that there's an agenda, number one. Number two, I've learned in my capacity at church that elected officials, and I don't mean any harm to those elected officials who are here, but two things you have to understand is they're employed, and they want to stay employed. They often vote with their colleagues, period. Number two, they come back to the community, and if the community doesn't have their back, if the church is not supporting them, then they're simply going to do what they need to do to stay elected. When they come back to our communities, the church has to say, here's what we believe. Here's what we want you to vote. And I'm going to be here when you get back to make sure you get reelected, but you must carry our voice with you. I got a call in my room during lunch from the Church of Scientology. We don't need to talk about the Church of Scientology. But they called me and said, Pastor Little, are you aware that there's a law being processed right now in the state of California that diminishes the priest privilege, where if you have someone in that meeting, that the privilege is gone, there's no confidentiality. Were you aware of that? I said, no, please send that to me. We need community. We need ecumenism. So we need to tear down the walls that separate us, right? Both in black community, Latino community, and white community, because this has become a faith issue. And so when you talk about what you just mentioned, whether it's the judiciary, whether it's the legislators, we have to understand how to go about grassroots activism. We have to understand how to tear down the walls that divide us, because we're not going to win this fight unless we stand together and united.
Amen. Amen.
All right, I guess I'm going to make a very brief last word, because it won't be as good as that. To me, when I greet rooms of conservatives, many conservatives just want to be left alone. They want to work in their communities, they want to support their families, they want to just be good citizens, and they want to be left alone. And the problem is, the paradox of limited government is that it requires you to be more active. If you retreat from that government sphere, the government will expand to meet your retreat.
That's right.
And so that, to me, is the main way that we've got to deal with these issues all across the board. Again, the paradox of limited government is it requires your maximum activity.
Amen to that.
I'm glad that you clarified, because I think when you spoke about the Nixon Amendment, you were referring to the formation of the 501c3 status. But I'm glad you clarified later on that the 501c3 status does not prevent the church nor the pastor to be able to be active in their community. It is a huge misnomer in our community, and it really needs to be clarified over and over and over again. You can have a 501c3, but you can still be active in your community as a pastor and as a church with the understanding of the guidelines. But the guidelines are broad enough
That's right.
that the churches don't have to be afraid. And so many pastors literally cower
Yes.
under the fear.
Yes.
Personally, I think all churches should rescind their 501c3 status and start standing for God and stop being Judases in our community and taking the money and not standing.
I won't say anything more to that. Amen. Thank you, sir.
Well, thank you. Can you give him a hand, please? Thank you so much, Marc Little and Peter Breen.